Welcome back to The Explainer, everyone. Today, we're diving into a genuinely fascinating piece of constitutional history. We're looking at a landmark 2001 Supreme Court decision, Clarence Pais v. Union of India. For any student of constitutional law, or really anyone interested in the complex intersection of civil rights, religion, and the legal system, this case is an absolute must-know. It rigorously tested the limits of religious equality in India and put the Indian Succession Act under a massive microscope. Let's get right into it.
To make this all crystal clear, we're going to break down this case using the classic legal framework, starting with the facts, hitting the core legal issues, the arguments from both sides, the court's reasoning, and finally, the ultimate judgment and its impact.
All right, part one, the facts. Every great legal battle starts with a real-world problem, right? In this case, original writ petitions were filed by members of the Christian community, spearheaded by a man named Clarence Pais. Now, the absolute key to understanding their hurdle is a legal concept called probate. So what exactly is it? Well, probate is basically a formal process where a court steps in to grant authenticity to a will. You literally can't establish your rights as an executor or a legatee, the person inheriting the property, until this happens. It's essentially the court's official stamp of approval. But here's the catch. Getting probate is a massive procedural burden. You're filing petitions, gathering evidence, paying hefty fees, and waiting around on the court's timeline.
And under Section 213 of the Indian Succession Act of 1925, this burden of probate wasn't applied equally at all. It's actually a pretty striking disparity. Check this out. If you were a Christian, mandatory probate was required everywhere in India, no exceptions whatsoever. But if you were Muslim, not required at all. And for Hindus, Sikhs, Jains, and Buddhists, it was conditional. It only applied in very specific geographic areas, like the former territories of the Lieutenant Governor of Bengal or within the local civil limits of the Madras and Bombay High Courts, or if the will involved immovable property in those exact areas. Talk about a geographic lottery, right?
So the real-world problem boils down to this. Christians faced an exclusive, incredibly expensive, and completely time-consuming procedural burden just to prove a will. Imagine two people living in Delhi, one Christian and one Hindu, and they both just want to claim the rightful inheritance. The Christian had to jump through all these costly, lengthy hoops of mandatory probate, while the Hindu, in this specific geographic scenario, absolutely didn't. Naturally, the petitioners felt they were being heavily penalized for literally nothing but their faith.
Moving on to part two, the core legal issues.
The petitioners didn't just complain about this, they launched a full-scale constitutional challenge. The battle lines were drawn across three major constitutional provisions. First up, Article 14. Which is the fundamental right to equality. Then Article 15, which explicitly prohibits discrimination on grounds of religion, race, caste, sex, or place of birth. And finally, kind of simmering in the background, Article 44. This is a directive principle that encourages the state to secure a uniform civil code for all citizens. So, Section 213, read alongside Section 57 of the Act, which detailed all these differing rules, was being put to the ultimate constitutional test.
Distilling all of that legal jargon down, the central constitutional question of the case was simply this. Was Section 213 unconstitutional and void for discriminating against Christians? Basically, did this highly selective procedural burden violate Articles 14 and 15? Keep that exact question in the back of your mind as we go forward.
All right, part three, arguments of the parties.
So how did both sides frame this for the Supreme Court? While the petitioners argued that the law was just patently discriminatory, they claimed the classification forcing them into probate was based purely on religion, which they argued was a direct violation of Article 15, Clause 1. They heavily emphasized the unfair financial and procedural burden, saying there was absolutely no rational connection between targeting Christians and the actual objective of the Succession Act. But the Union of India, the respondent, had a totally different lens. They defended the law by arguing the 1925 Act was just a consolidating statute, meaning it merely brought together older, pre-existing laws. They insisted the classification wasn't based solely on religion, but rather on these deeply embedded historical and geographical factors in Indian legal history. They basically said, hey, the legislature has the rightful discretion to apply laws in a phased or territorial manner.
Which brings us to part four, the reasoning of the court.
So how did the Supreme Court, and specifically Justice S. Rajendra Babu, untangle this massive knot? Well, he pointed out a really crucial nuance in Article 15. For a law to be struck down under this specific article, the discrimination must be based only on religion.
That one word only became the absolute pivot point for the entire decision.
Let's break down the court's logic here step by step. First, they noted that Section 213 wasn't just targeting Christians in a vacuum. Its application was heavily tied to the historical development of law in the old presidency towns. Because of that, geography and history were active, major factors in the classification. Therefore, religion was not the sole criterion. It wasn't only religion. Next, the court looked at the actual purpose of probate. They noted it serves a really legitimate purpose, establishing authenticity and protecting estates against fraud. Just because the legislature made it mandatory in some historical cases and not others, didn't automatically make it unconstitutionally arbitrary. And finally, the court fell back on a bedrock legal principle. There's a strong presumption in favor of the constitutionality of any given statute, and the burden is squarely on the petitioners to prove otherwise.
This next quote really brilliantly illustrates the court's mindset. Justice S. Rajendra Babu stated, "It is on account of historical reasons that different systems of personal laws have come to be evolved." The court was basically acknowledging that, yes, India's legal landscape regarding wills and succession is totally fractured along religious and territorial lines, but they view this as a product of really complex history, not just purely hostile religious discrimination.
Which, of course, brings us to the elephant in the room, the Uniform Civil Code under Article 44. The court definitely acknowledged the clear disparity here. They clearly saw that different rules existed for different religions, but they firmly ruled that bringing about uniformity is the prerogative of Parliament, not the judiciary. The courts can't just strike down a valid historical law simply because it fails to be perfectly uniform across all citizens. Writing the laws? That's the legislature's job.
Finally, Part 5, Final Judgment and Impact.
All right, we know the reasoning, but what was the immediate verdict? The final ruling was definitive. The Supreme Court upheld the constitutionality of Section 213 and dismissed the writ petitions entirely. The legal challenge failed. The court officially held that the statute did not violate Articles 14 or 15 of the Constitution, specifically because it was rooted in geography and history, not solely in religious bias.
But you guys, the story doesn't end in the courtroom. Let's walk through this timeline because it perfectly shows how this case acted as a massive catalyst for change. In 1925, the act mandated probate for Christians. Fast forward to 2001, the Supreme Court upholds the law, but, and this is critical, the court explicitly acknowledged the procedural hardships faced by the Christian community in their judgment. They basically put a huge spotlight on the issue for the lawmakers. And look what happened the very next year, in 2002. Parliament stepped in and passed the Indian Succession Amendment Act. This amendment officially removed the mandatory probate requirement for Christians. So, the biggest takeaway here? The petitioners lost the battle in court, but by forcing the issue into the national spotlight, they ultimately won the war in Parliament. They got the exact relief they were looking for.